Two people, same street, same night. Both are stopped by police and have the exact same amount of drugs in their pocket. One walks away with probation, the other one is facing years in state prison. So what's the difference? In New Jersey, the line between simple possession and intent to distribute isn't drawn by how much is found. It's based entirely on what the state believes it can prove. And that distinction can mean the difference between probation or treatment and going to state prison. But intent isn't always obvious. It's built from small details, how the drugs are packaged, where they're found, and what surrounds them. See, these details matter, and that's how nearly identical cases can go in completely different directions. Over the next few minutes, I'm going to break down how New Jersey prosecutors decide between possession and distribution, and what triggers that leap, and how skilled defense strategy can dismantle those assumptions before they can ruin a life. Hi, I'm Daniel M. Rosenberg. I'm a criminal defense attorney, and I've represented countless individuals who have been charged with possession with intent to distribute. I've also had the opportunity to prosecute those when I was a former county prosecutor. And the difference between being charged and prosecuted with straight possession versus intent to distribute is razor thin. And it's all in the eyes of the beholder, which is scary stuff here. So here's what the law in New Jersey actually says, and that's possession means having a controlled, dangerous substance for personal use. Intent to distribute means the state believes it was meant for sale or for transfer to others. And while the quantity helps shape that theory, it certainly doesn't tell the full story. Even a small amount of drugs can lead to a distribution charge if they're found with evidence that suggests intent to distribute, such as cash, packaging, or communications relating to distribution. More often than not, the state is arguing intent based on the surrounding circumstances. Not only is it the amount of drugs that were found, but what manner were they found? Were they in multiple bags? Were they in one bag? Was there a scale? Was there cash? Are there Venmo transactions? Are there text communications? The bottom line is that the difference between possession and being charged with intent to distribute lies entirely on how the story is told. Let me give you a real-world example. I had a client who was found with a few grams of drugs, no scale, no cash, no baggies, was charged with straight possession. We got him into treatment. Those matters were ultimately expunged. We had another client who had even less drugs on their possession, but with a Venmo message and 2 empty baggies nearby, that person was charged with intent to distribute, and we had to fight like hell to get them out from under that. Similar facts on paper, drastically different approaches to the prosecution. So when this happens, we have to start dismantling the state's case immediately. They're claiming that it was someone's intent to distribute. Says them. Number one, how are the items found? Is it a lawful search? Number two, what does the possession of the items really mean? It could mean intent, but it could mean so many other things. Like, I have a drug problem, so that's why I have a larger amount of drugs. Or, I like to separate my drugs so I don't take too much on one day or too much on another. What's the reason for the Venmo transaction? There's nothing illegal about exchanging cash in a Venmo app. What can the state prove when it comes to a cash transaction or a Venmo transaction? What are the circumstances surrounding that transaction? Did somebody owe you money? Were they sending you money for a fantasy football bet? Were they sending you money for other reasons? Did you owe them money? These are all legitimate reasons to have transactions, and just because you're possessing drugs doesn't mean that it's your intent to distribute. And if the search was unlawful or the evidence chain is weak, the state's entire narrative collapses. Expert testimony, context, and forensic review often reveal what looked like distribution was really personal use or nothing at all. And the reason this is critical to know is because the difference can change your future entirely. If you're charged and convicted of possession with intent to distribute, and you're within a certain distance from a school zone, that's enhanced fines and penalties and enhanced prison time. If you're near a public park or public housing, that's enhanced prison time. And when you're charged with distribution and convicted, that sets you up for what's called an extended eligible sentence. Meaning, if you get a second possession with intent to distribute, you're now eligible to be sentenced to an extended term of imprisonment. Which means if you get a second conviction, the state is looking to put you in prison and for longer than they normally can. Even if you don't get an extended term, that gives the state leverage. They hold that extended term over your head to force a resolution down your throat. So if you or someone you know has been charged with a drug offense, whether it's a possession or distribution charge, contact our office. We'll take the time we need to review your facts and situation, give you blunt and candid advice, and tell you what we can do to put you on the path to get the best possible result. We have your back. That's what we do.